Hello, my name is Josh Blackman. I am the president of the Harlan Institute. It is my honor to welcome you to the 2020 Harlan Institute Ashbrook Virtual Supreme Court Competition. This year, we're arguing the case of Torres versus Madrid. I'm honored to be joined by my colleagues, Chris Riano and Curtis Herbert, who will be my judge in the panel today. Today, we have two wonderful teams. Petitioner Team 7859 from Texas. We have Makaylia and Elizabeth. And we have Respondent Team 7988 from Connecticut. We have Stephen and Benjamin. Petitioners, you may begin whenever you are ready.
May it please the court, my name is Makaylia Askew, and along with my co-counsel, Elizabeth Adeoye, we represent the petitioner, Roxanne Torres. We are arguing that Torres was seized under the Fourth Amendment because, one, at common law, a seizure does encompass an unsuccessful attempt at detaining a suspect, and two, when comparing false imprisonment to an unsuccessful arrest, there is a clear violation of the Fourth Amendment, and three, the lower court's ruling is inconsistent with the ruling in California v. Hodari.
In 2014, in Albuquerque, New Mexico, two police officers, in an attempt to stop a woman named Roxanne Torres from fleeing, shot at her, hitting her twice. Despite this, she was not physically detained until she was admitted into the hospital. In 2016, Torres filed a civil rights complaint in a federal court against the officers, claiming that the intentional discharge of force is exceeding the degree of force which a reasonable law enforcement officer would have applied. The court held that the officers were entitled to qualified immunity, and was reasoned that the officers had not seized Torres, and therefore no Fourth Amendment violation had occurred.
In evaluating the scope of the protections under the Fourth Amendment, the court in Wyoming v. Howington found that it inquired first whether the action was regarded as an unlawful seizure or search under the common law when the amendment was first framed. And even before this approach was even embraced, Your Honors, several courts were already describing the significance of this rule as shedding light on what the framers of the amendment might have thought to be reasonable. And as Payton v. New York states, the Fourth Amendment is to be constructed in the light of what was deemed an unreasonable search and seizure when it was adopted, and in a manner which will conserve public interest as well as the interests and rights of the individual citizens.
Counselor, if I could just interrupt you briefly. We talk about what the Fourth Amendment meant in common law. What do you think is your leading precedent? What's your strongest authority to interpret the meaning of seizure under the Fourth Amendment from the common law era?
Your Honor, our leading precedent today is going to be California v. Hodari.
Well, maybe let's go back a little bit further. Maybe the English courts, 1800s. What's your best precedent from the common law era?
Your Honor, that would probably be Hodges v. Marks, where they held that when an officer places a hands on a suspect, regardless of whether or not the detainment is successful, that is a common law seizure.
Okay. Was that a civil case or a criminal case?
I believe it was a criminal case, Your Honor. However, it's not necessarily the civil versus criminal. It's the holding that we want this court to look at when deciding the ruling of this case.
Okay. So let me ask you a follow-up. Justice Riano, please go ahead.
No, I was just I'm so curious about this because, counsel, you're clearly focused, and rightly so, reading your brief and reading and thinking about your arguments about the success of the seizure. Can you say more about how that is really critical to finding in your favor?
Well, Your Honor, as I've stated before, Hodges v. Marks held that when the court, that both before and during the founding era, the arrest occurred when the officer touched a person with the intent to arrest them. And in today's case, officers Williamson and Madrid both acknowledged that they shot Torres in an attempt to stop her flight. This is impeding on her right in the Fourth Amendment of freedom from searches and seizures on her very own person.
But she wasn't seized, right? She wasn't seized.
Excuse me, Your Honor.
No, please go ahead. Please.
Under the common law definition of arrest and California v. Hodari, a common law arrest is significant when the officer touches a person, even if it does not immediately stop the person's movement. So even though Torres did drive away,
but it didn't stop her movement at all, did it? In fact, she was able to drive 70 plus miles. So there wasn't any stopping of movement at all. In fact, in many ways, while the officer's intent, and I agree, is very important, there's no seizure at all. Or tell me how there is. And I'm curious to hear your thoughts on that.
Well, Your Honor, there is a seizure because, well, when going back to California v. Hadari, they created this intricate analysis that, and it's not necessary when an officer applies physical force to an attempt to apprehend a suspect. But however, the common law on arrest leaves no doubt that in today's scenario, a seizure has occurred because they still seized her person, regardless of the subsequent flight.
Can I ask if that really then turns on the individual who they are attempting to seize? So if you have an individual who's just able to constantly escape, that means that the Fourth Amendment treats that individual differently than somebody else who wouldn't be able to escape from the intent of the officers.
Excuse me, Your Honor, would you mind rephrasing your question? You kind of
Not at all. No, not at all. In fact, if anything, I think I'm curious to know your thoughts then on how much of this turns specifically on the individual who is at issue, because if we remove the intent of the officers from the equation, it really comes down to the individual who they're attempting to seize. And if this individual is particularly able to consistently not be seized, does the Fourth Amendment really treat them differently than a normal individual who's been shot and is not driving away for 75 miles?
Well, Your Honor, with that bar, it would be, of course, if Torres had, subsequently fled over several days, then of course the Fourth Amendment would not apply to her. However, had the officers not used their excessive force of shooting at her car 12 times, 2 shots hitting her in the back, thus ending her up in the hospital, they would not have detained her at all, and therefore it is a seizure.
If I could maybe ask a question of Elizabeth, I want to make sure you both get a chance to participate. Let me ask hypothetical. If I tap someone on the shoulder, is that a seizure?
Well, no, Your Honor. The reason why that tap on the shoulder would not constitute a seizure is because that tap on the shoulder was not intended to actually seize the person.
But what if I have a really strong finger and I tap them trying to stop them? It's like, excuse me, stop what you're doing. And the person, they get scared and they stop. Is that a seizure?
Well, even so, even if it could stop the person, if you did not intend for them to physically stop and for you to go into questioning, if under the hypothetical that you were an officer, then there was no actual seizure taking place, no matter if the person stopped or not.
Well, one more question. How do we know what an officer's intent is? Do we ask them what they think? Do you think they're going to give us, the true answer? I mean, how do you know an officer's intent?
Well, in this case, we can see the officer's intent because of the fact that the officers actually thought that Roxanne Torres was doing something that needed to be pulled over and potentially detained for. Also, the fact that no officer would reasonably begin shooting at a car 12 times if they did not intend to actually stop the person in the car.
Justice Herb, I'm sorry, do you have a question?
Well, I'm just wondering, say a military sniper shoots at a suspect, and for purposes of the hypothetical, we'll ignore all questions, about other areas of law, and they hit them. Is that a seizure even if it's from a mile away?
Well, yes, Your Honor, it would be a seizure because of the intent. The sniper in this case was shooting at that person with the intent to stop their movement. And if we're looking outside of that situation, to take them into detention or to give them further questioning. So it would constitute a seizure.
Sure, but I mean, if I were to tell you I'm going to seize this pen, would your understanding of that sentence be I'm going to tap this pen and try and grab it? I mean, it seems to me that normally when we say we're going to seize something or somebody, it means we're going to grab it and take control of it and hold it for some period of time. Why isn't that the understanding of seizure that we should apply in this case?
Could you please rephrase your question, Your Honor?
Certainly. So normally, I don't think the word seizure means you're attempting to exercise control over something. I think it means you're going to grab it and you're going to hold it for a certain period of time. Why shouldn't we use that more normal definition of seizure for the Fourth Amendment rather than a more convoluted common law test?
Well, Your Honor, if we were to specifically talk about the pen that you were just referring to, then that would more apply to a seizure of property than of a person. And because of that, we can see that if you are aiming to actually seize a property, you are seizing that in order to find further information from that property. So that's why we should look towards the actual definition of seizure outside of the context of a person when we're looking to take something in and get further information from that.
Are there any dictionaries that might help your definition of seizure?
Well, dictionaries or any previous case law, Your Honor?
Well, dictionaries, perhaps.
Well, I would say that I know that there's previous precedents, such as in Carpenter v. United States, that could give us an actual law definition of seizure. But I can say that for any reasonable dictionary can actually define that. If we're actually looking at Samuel Johnson's A Dictionary of the English Language, there's also a definition of seizures that we look to.
Very good. You have about 10 seconds left, Councilor. Sorry, we took all the time with questions. Anything else you want to add in closing?
Well,
Please.
to rule in favor of the respondent would significantly weaken the Fourth Amendment's value in protecting individual liberty from unjustified government intrusions. It is for these reasons we pray that the court rule in favor of the petitioner, Roxanne Torres, and reverse the ruling. Thank you.
Good. And I'm happy to give you those 13 seconds. I think I told you the timer glitched. It's on this thing where every 2 hours it resets. So I think it's why it shut off the middle, and I apologize. If I shorted you time, my apologies. Okay, thank you so much. Petitioners can turn off their cameras and we'll go to the respondents now. And Aaron, I think just turn your camera off. I think oh no, you're not, your camera's off. Okay, that's fine. Okay. All right, 15 minutes for respondents. You can begin whenever you're ready.
Mr. Chief Justice, may I please the court? The question presented today before the court is whether or not an unsuccessful attempt to detain a suspect by use of physical force constitutes a seizure within the meaning of the Fourth Amendment. We answer this with a resounding no, and we urge this court to affirm the 10th Circuit's ruling in this case, Torres v. Madrid, that no seizure occurred.
The fundamental qualification for determining a seizure lies in whether freedom of movement is restricted. In the 10th Circuit Court's decision, they referenced Brooks v. Gainesley, a case in which Officer Gainesley shot at Mr. Brooks, who fled in an unsuccessful attempt to detain him. In Torres v. Madrid, the 10th Circuit found the officer's force failed to control the ability to evade capture or control. Brooks v. Gainesley said a seizure requires restraint of one's freedom of movement.
This same requirement for a seizure is present in this court's decision in Broward v. Inyo County, which was a 9-0 decision. The ruling for Broward states that there needs to be a termination of movement in order for a seizure to occur. A termination of movement would mean freedom of movement would not only have to be restricted temporarily, as brought up by the petitioner, but also permanently, which is clearly not evident in Torres v. Madrid. With Brooks and Broward in mind, Torres's movement failed to be restricted, so no seizure occurred. Torres drove away from the police officers, left her car, stole another car, and continued to drive for over 75 miles. Clearly, Torres maintained the freedom to move, and the officer's force failed to inhibit her ability to evade and capture or control. With this mountain of precedent alone, Petitioner Torres was not seized.
Councilor, if I could just interrupt for a moment. So is your test that for there to be a seizure, the police must be successful? Is that your test?
Yes, yes, Your Honor, that is correct.
So let me ask this question, right? In this case, we have Superwoman, right? Wonder Woman, right? She was shot, was it 13 times? She didn't go down. She managed to drive 75 miles with a paralyzed arm, make it to another town. I mean, not everyone is a superhuman, right? Most people are mere mortals, right? Not everyone's gonna be Thor, right?
Yeah.
How do we write a Fourth Amendment test that depends on a person's ability to withstand bullet shots? Like, how do we write that opinion that it's not a seizure if you can withstand being riddled with bullets?
Yeah, so this is often clarified in multiple precedents. In one precedent in one of the lower courts, Henson versus the United States, it was not necessarily a gun case, but it was ruled that the appellant, who happened to escape the grasp of Officer Jones and was later captured after tripping up himself, that in that court, they ruled that the individual was not seized when the officer grasped or grabbed Henson, but only when the Henson tripped and was detained by the actual officer. So you can actually draw
again, though, based on the attributes of the suspect. In other words, he tripped. He was a klutz, right?
Yes.
What if he didn't trip? Then it wouldn't be a seizure?
Then it would not be a seizure because the seizure would only occur once that suspect would be detained. In fact,
so really, your test is not based on what the police do. It's based on the specific attributes of the suspect. Is that right?
I think that is, I understand where you're coming from with that, but I think that it really just has to do with the kind of force that's applied, because sure, someone may be more resistant to a bullet, like someone might not have been as strong as Torres and wouldn't have been able to drive after those bullets, but that would mean that the force was successful and that they have the ability to move. I mean, this is a question of liberty. And when you still maintain the liberty to be able to move, when you're able to have that freedom of movement, then you can't have been seized. It's a matter of inhibiting liberty, and whether a certain amount of force is enough to inhibit your own liberty based on how strong you are, well, that just has to do with the kind of force, and that's just part of the law, and that's part of being a police officer. It's judging how much force you should apply.
Can you point, Counselor, to a place in the law, and it doesn't have to necessarily be case law, but I'd like to think historically wide, where liberty is read into the Fourth Amendment?
Yeah, so there's the word seizure. I mean, if we're going through old dictionaries, like Samuel Johnson's Dictionary of the English Language of 1785, it defined a seizure as the act of taking forcible possession. And in 2019, the definition has not changed, because it's also talking about the act or an instance of taking possession of a person or property by legal right or process. So this act of taking possession, when you have possession over someone else, they're essentially losing their liberty in order to move. It's about the freedom of movement. And it's the same freedom of movement, the same liberty that's mentioned in Brooks v. Gainsley. And that also can kind of bring us to the infamous and contentious California v. Hodari D decision that comes up in both. Now, in this case, with Hodari D, Hodari was running from police officers and discarded drugs during a chase. The question was whether the seizure occurred during the chase or after the tackle, and the court found the latter to be true. In the decision, a hypothetical situation in which the officer touched but failed to gain possession of the suspect was imagined, stating that a seizure can be laying on of hands or application of physical force to restrain movement, even when it is ultimately unsuccessful. Now, this is a passage that the petitioner relies on.
So you don't mean the Fifth Amendment or 14th Amendment concepts of liberty. So you're not reading a substantive liberty argument into this. You're instead using liberty in an entirely different context when it comes to essentially freedom of movement, based on what I'm understanding.
Yes, Your Honor. We're talking about it in terms of freedom of movement. Now, back to Hodari D. Now, what they rely on is this whole ultimately unsuccessful bit, which is from a hypothetical situation detailed in there. However, this passage also challenges other sections from the same exact case. The court stated in Hodari D that for the entire nation's history, the word seizure has meant a taking possession, which we also proved through the various old and new dictionaries. Now, the court continued to state that an attempted seizure is not a seizure in the same Hodari D opinion, based on common law precedent.
What if we think that Hodari D, the language that's bad for you in that opinion, isn't dictum and that it's applicable to this case? I understand you have a lot of arguments, say, well, it's dictum and you distinguish it. What if we disagree with those arguments and we think it is applicable? What are we doing? What are we stuck with? Do we have to overrule the case? Do we have to just rule against you?
The bit that's in contention, that ultimately unsuccessful bit, fundamentally undermines our side of the opinion, but there's really truly is an overwhelming amount of evidence that suggests it to be dicta. And the reason why we're talking about this case today is because there is a conflict in Hodari D. There's this bit about attempted seizure not being a seizure and seizure taking possession, yet somehow if you fail to actually restrain movement, then it's supposed to be a seizure. And that's where the conflict arises in this case. And the long-standing definition of the term seizure is a taking possession, and some of the previously mentioned precedent in addition to other precedent that requires an absolute restriction of movement for a seizure, proves that the petitioner's excerpt from Hodari D is non-binding dicta. And
what if we don't think it's dicta though? Do we have to overturn the case? Are there other cases that maybe weigh against Hodari D and suggest that even if we think it's applicable, it should be given less weight? What do you think we should do?
Yes, Your Honor. So there are two major cases which weigh against Hodari D. And these two cases I'm talking about is Broward versus Inyo County and Brennan versus California. Broward v. Inyo County outlines that restriction of movement may occur if there is a use of physical force. And if there is use of physical force that successfully restricts one of the suspect's movement, then there would be a seizure. And Brennan versus California, Brennan was a person who was a passenger in a traffic stop. And thus, that was an action that acted as a submission to authority. So if there's also a submission to authority, obeying the police, that would also act as a seizure. In Torres v. Madrid, Torres was not physically seized as she was able to freely move away. So the bullet was not successful in doing that. And she also did not submit to the authority to also restrict her movement as she clearly left the police.
Does the intent of the oh, go ahead, Justice, go.
Just one last question. If we're not taking Hodari, what's your substitute test that you're proposing if we're not considering seizures or attempted seizures that were ultimately unsuccessful? Those don't fall within the purview of the Fourth Amendment. What tests are we using to determine what that is?
Yes, Your Honor. The test we would be using would be a combination of what we see in Broward and Brennan. The first test would be to verify if the physical force used to try to detain the suspect was successful. And this would obviously be evident in if that person was forceful and against the suspect. And the second test would be if the first test is not passed, is if the suspect was able to submit to the authority. If they don't do either of those two, then it would not constitute a seizure.
And we've seen this sort of weighing used before. In a case, Mendenhall v. United States, it was said that a seizure requires either a show of authority or restraint of freedom of movement. And there really is a long body of precedent that supports this kind of weighing. And essentially, as we've shown through the conflicting quotes in Hodari D, and the reason why we're here today is really to settle this, is to settle what part of Hodari D should be taken as precedent and what really needs to be taken more as dicta. And just the long body of precedent and the fact that the quote from Hodari D about it being ultimately unsuccessful was actually from a hypothetical and was irrelevant to the actual decision of Hodari D. And the reason that is because the force that was applied in Hodari D, the tackling, was successful, whereas the point that the petitioner relies on is about an unsuccessful bit, which isn't even relevant to the actual decision. So that when weighed with just precedent after precedent, whether it's Brennan, Brower, Brooks, or Henson, it really is why we strongly believe that we need to weigh freedom of movement and over whether a force is successful or unsuccessful or not. And this also, I know our opponents like to use old cases of common law. However, as we can see from the lack of change in the definition of the term seizure from 1785 to 2019, it all refers to a taking of possession. And if a force is unsuccessful, you can't have actually taken possession of the person because they're able to move and able to leave, and they've maintained.
If I could, let's just bring this back to reality for a minute, right? The police shot this woman 13 times, right? How is that not a seizure? I mean, come on. If someone shoots you 13 times, shouldn't you be able to sue them for damages? Isn't that like an easy case?
Well, one thing that prevents this case from being so easy is the precedent set that allow a test to be verified if these actions of the officers were reasonable or unreasonable. And there's actually three precedents that determine this. One of these precedents is Graham v. Connor, the second is Terry v. Ohio, and the third is Scott v. Harris. But I'm going to focus specifically on Graham v. Connor. So Graham v. Connor essentially outlined that there was a non-exhaustive list of factors for determining when an officer's use of force is objectively reasonable. The first is the severity of the crime at issue. The second is whether the suspect poses an immediate threat to the safety of the officers or others. And the third is whether he is actively resisting arrest or attempting to evade the arrest by flight. And we can see actually it passes every single one of these cases. The severity of the crime at issue, they had believed her to be acting in a very suspicious manner. And there was an arrest warrant for a very violent criminal. For the second case in which they posed an immediate threat to the safety of the officers, both Officer Williamson and Madrid testified that they feared for their lives as Torres acted in a very erratic manner and drove her car forward, aiming at Madrid. And the third and final condition on whether he is actively resisting arrest or attempting to evade flight, that is easily proven as Torres immediately began driving away from the officers and trying to evade arrest or detainment.
And to add on to a response to that question, we aren't really here today to completely decide what happens to Torres in her fate. That really is up to the lower courts. What we are here today to do is determine what really constitutes a seizure, and more specifically, whether the success of applied force is an important consideration. And we obviously say that the force needs to be successful, and that's just due to the countless definition, the constant definition of the term seizure with regards to the possession, the quotes from Hodari D that conflict with the one truly substantive piece of evidence that shows an unsuccessful force being evidence of a seizure, and also just the consistent long body of precedent.
And I also want to lastly emphasize the importance of the decision, what the impact of siding with Torres may be. Under the petitioner's definition of seizure, a mere touch could constitute a seizure. The only limit they have is whether the officers intended to seize the suspect. Now, that is very subjective. It could be it is very hard to determine, but in essence, a simple brush,
Tap on the shoulder,
or a bullet graze could easily be a seizure, even if it doesn't actually take possession of the suspect, or if it even if it has a little contribution to the actual arrest. And because of this, we urge this court to affirm the 10th court decision and maintain the status quo that we've been having ever since our founding fathers established the Constitution. With that, thank you.
Excellent. Thank you so much, Counselor.
Thank you, Your Honor.
All right, please go off camera. If the petitions come back, we have a 5-minute rebuttal period, and begin whenever you're ready.
May it please the court, my counsel and I will be making 2 points in our rebuttal today. One, that Torres was seized under the common law definition of arrest. And two, California v. Hodari is a substantial case in regard to deciding the ruling of today's case.
Now, in addressing whether Torres did not surrender to the officers or immediately stop her movement, opposing counsel states that she did not, because she did not stop her movement. But according to Broward versus Inyo County, a person is seized when an officer successfully stops the suspect's movement. However, in said case, the defendant was not shot, but actually died to the police roadblock. And the court even held that the roadblock was an illegal seizure under the Fourth Amendment.
Counsel, let me ask this based on what the opposing party was arguing.
Yes,
there's a huge amount here about whether the seizure must be successful. They are arguing very strongly based on history, based on definitions, that success of the seizure is critical. How would you counter that?
Well, Your Honor, they're using different precedents, but if we were looking at the actual definition of a seizure under common law and under dictionaries that have already defined seizure, it only outlines the different points that it must have intent and it must have the possibility of actually stopping the person to actually make it a seizure. So despite all the precedents that opposing counsel may refer to, it still says under common law definition of a seizure that a seizure would have occurred under the actual happenings of this case.
Do you think that there's a difference here based on the fact that she was shot? Meaning, is the use of force and or the amount of force important in determining whether there was a seizure or not, regardless of success?
Yes, Your Honor. I believe that while that may be a point that could be brought up, if we're looking at this specific case, the shooting that happened was used with the intent to stop Ms. Torres from fleeing, which would be a seizure. Which would be a seizure. Does that answer your question, Your Honor?
To address our second point, California v. Hodari is not dicta because contrary to the opposing counsel's contention that deciding whether an unsuccessful detainment was not related to the holding of Hodari and thus dicta, one of the clear issues before that court was whether a person who is not under the physical control of a police officer being seized under the Fourth Amendment, which the court even unanimously recognized that when a government officer inflicts physical force on a person with the intent to restrain them, the person is seized within the original meaning of the Fourth Amendment, regardless of whether or not the restraint is successful, and that the Fourth Amendment clearly encompasses the common law definition of arrest. To uphold the 10th Circuit Court's ruling does little to advance the interests often described as underlying the Fourth Amendment. Under the 10th Circuit's rationale, the application of the Fourth Amendment would hinge on an individual's unpredictable physical reaction to state violence. This interpretation would exclude the constitutional review extraneous scenarios where an individual posing no threat continued movement after an officer struck them with a bullet. The Constitution must compel otherwise.
Let me ask you a question, Counselor. What about the tapping on the shoulder example that your counselor had, right? Why is grazing someone on the shoulder, not a seizure?
Well, Your Honor, because the issue before the court today and what the Fourth Amendment protects is excessive force. If I'm next to you and I simply tap you on the shoulder, I'm simply exactly tapping you on the shoulder. In today's case, the officer's first instinct was to shoot.
I get that. They riddle this one with bullets. It was gruesome. But the Supreme Court sometimes has to decide issues beyond what's just before us today. So what happens if tomorrow someone else comes to this court and they were just a tap on the shoulder and they sue for a seizure? Why do we turn that plaintiff away?
I believe in that circumstance, it would depend on through the eyes of the police officer, how reasonable that would be, and through the eyes of the citizen. If the police officers barge through the door and then tap me on the shoulder, the court may find that it's not an unconstitutional seizure. But if the police officers barge through the door and tap me on the shoulder so hard I flail over, that could be an unconstitutional seizure.
Okay, that's 30 seconds left. Counsel, if you want to wrap up.
It is for these reasons we pray that the court rule in favor of the petitioner, Roxanne Torres, and reverse the lower court ruling. Thank you.
Excellent. Thank you so much. All right. If the other team could please come back on camera. And Aaron, you're allowed to come on camera also if you want. Let me congratulate all of you. That was absolutely spectacular. I don't know how you all do it. Every year, I think the students get stronger and stronger. You have to know the questions we're throwing at you are the same sorts of questions we throw at law students, no different. And you have held yourselves just as well, if not better, than some law students which we've seen. So it's truly, truly impressive how people at your age group are able to pull this together. You're pulling in precedents, you're pulling in 300-year-old dictionaries, you're pulling in cases from the English common law. You're talking about, oh, Scalia meant this, oh, Scalia meant that, right? We're giving these hypotheticals about tapping you on the shoulder and, grazing with a bullet. And these are hard hypos. And the reason why we ask these hypos is to try and throw you off, because once you deviate from your position, we're going to nail you, right? We're going to nail you. And that's why you have to sort of hold the line and not give in to the sort of insane hypotheticals, which I like to give students, right? You hold your ground. And when you hold your ground, it gets respect from the judges, and it's very strong. So I have to commend Makaylia, Elizabeth, Stephen, Benjamin. These were really strong performances. I'm just truly in awe of what high school kids were able to do. This is really remarkable. I'm blown away. So thank you all. Chris? And then...
I just have to echo that. So, I mean, there's nothing, first of all, everybody take a breath, because I can see everyone's like, whoa, oh my goodness, it's done. It's done. So you should all take a deep breath. And I will say nothing makes me more excited than to see 4 incredibly strong high schoolers, because just like Josh mentioned, this is just as good, if not better, than I have with my law students. And nothing makes me more excited than when I see really strong arguments out of the gate, because I think to myself, you know what, game on. Let's talk about these hard issues. Not one of you shied away from a question. Not one of you. That is extraordinary, because I can assure you that Curtis, myself, and Josh can come up with about as hard of the questions as you're going to get. And the better you do, the harder our questions are going to get. Each of you, I mean, literally, each of you was able to take these and run. That's amazing. You should be so proud of yourselves. The briefs, excellent. I've read them. I looked at them. I used them to formulate questions. I quickly realized that you all were so well prepared. I wasn't even going to use the briefs for questions because it wasn't even necessary. The here and now is enough. You should all be very, very proud of yourselves. That was truly, truly well done. I know how much work goes into this. I've prepped myself to do oral arguments. I know how these work. And there wasn't a single moment with any of you where I thought to myself, that's a little off. On the contrary, you kept bringing me to new places that I was thinking about. And that's what I enjoy about this. So really, Benjamin, Stephen, Makaylia, and Elizabeth, you should all be very, very, very proud of yourselves. That was exceedingly well done.
Curtis?
Yeah, it was really, really quality round. It was a lot of fun to be involved in. I think the trick is to be polished and prepared, but also have good substance. And I think every one of you was polished and prepared, but also had good substance. You're very smooth. It was it's always a hot bench, but it was definitely a hot bench today as well. And you guys didn't seem very flustered. You did a really good job of answering cleanly and then transitioning, or of answering and then if you got cut off in another question, just answering that and then transitioning from there. And the substance of your answers was very quality too. So I was very impressed. I'm glad I wasn't competing.
And
against all of you guys.
Curtis is actually a freshman in college. He participated in this competition some years ago. So maybe one of you will come back to judge around when you guys go to college. I'd be happy to have you. And Makaylia's doing this forever. This is it's your fourth year, if memory serves, or third year?
It's my fourth year. I'm a senior this year.
Oh God, you're graduating. Well, that's so exciting. And Aaron has been in this competition for many, many times before. So I'm so happy to keep fielding wonderful teams. I always want to ask, are there any questions that you have of us about law school or attorneys or law or whatever you want? Free reign. You got our attention.
This is kind of random, but how many rounds have y'all been doing?
All right. So this year, we advanced 24 teams. So we're doing 12 today, Saturday, and 12 tomorrow, Sunday. I don't know how many are going to the next round because you're all so good. I may increase the field. I don't know. I'm going to look carefully at the scores after today or after tomorrow. At a minimum, we're advancing 4, 2 and 2. So there'll be a final 4 type round. That's the minimum. I may go more. I don't know. I can't promise because I need to look carefully at the scores. And if they're really clustered, I may just advance more teams. So there may be more in store. But I have to. The judging today has been tough. We've had some really good teams. Chris was on it all morning with me. Curtis joined recently. I have 1 more round after you today. I have 6 more tomorrow. Just the competition has been really strong. You asked a good question. I don't know the answer, but I will email your coach by Monday. That's for sure. Also, I want to make a note to Aaron and also for your other students. I teach a First Amendment class this semester. It's on Zoom, of course. It's Mondays and Wednesdays. It's 2:30 Eastern, 1:30 Central. If any of you want to come to my class this week or next, you're welcome to come. School's over after next week, so I have no more classes. So it's either going to be this week or next. But you're welcome to come to my section. You can sit in on Zoom. So that'll be a Monday, Wednesday, 1:30 Texas time, 2:30 Connecticut time. And I'll give your teacher the address later for Zoom. But you're welcome to come in and just watch. And I may cold call you and ask you a question, or you can raise your hand and ask me a question. It's fair game. But I think you're all such bright students that you will be at place in a law school whether you know it or not.
Well, thank you so much for that invitation. We're on break this next week, but I will check to see if it lines up with our class period for the week after. But if you do send it on to me, I'll at least let Stephen, Benjamin, Skylar and Veda know that they could come this Monday or Wednesday during their break.
Yeah. Even if it's just on your phone, you don't have to have your camera on. I just want you to watch, see what it's like.
Awesome. Yes, please forward that. I will pass it on.
We'll do that later tomorrow. I promise.
Great. Thank you.
Any other questions that you guys have for me or Curtis or Chris?
Yeah. Is there a particular Supreme Court case that you find most intriguing or is your favorite?
Oh my God, Chris, how do I answer that question? Chris, you answer that one first. I think I know which case. Got a book over his shoulder.
Okay, I will say this. You know what, Benjamin, I will say this. As opposed to thinking of a case, I will most certainly say, I most certainly have one of my favorite amendments that we don't talk enough about, which is the 9th Amendment. And I can absolutely give a great example. And I can totally give a great example of why I find that so fascinating. I was giving a lecture at the Second Circuit Court of Appeals with a bunch of judges from the court. And right before we went out to give the lecture, I looked to my left and right to federal, Second Circuit judges and said to everybody, I'm well aware that we're about to give a 90-minute speech that none of us have a clue about. And everybody had a good chuckle. And then everybody realized that's absolutely true. And then we went out and gave a 90-minute speech about an amendment that is really interesting. So the reason that I'm bringing that one up is because I think, as opposed to a specific case, because I could probably come up with a couple that I'm like, yeah, that's a big one. That's a really important, seminal discussion of American, values and constitutional values. I think that the thing that I would hope to come away from a competition like this and thinking about the Constitution is not necessarily just a specific holding in a case or a specific way a case looked, but much more of the constitutional panoply of how this all works together, and how when you take human rights and natural law and natural rights, you bake it in with positivism and this creation of law like a constitution, and then you look at the realism of how this really works. I think that's a really fascinating journey to take, because it takes us all the way back to human rights and natural rights. And so when you think about that big system, the Ninth Amendment's a great example of something that doesn't make a lot of sense. You can look at the history, it doesn't necessarily make a lot of sense, but it says a lot, I think, about the American experience over the last 200 plus years. And so that's actually what comes to mind as a really great example, as opposed to a Snyder v. Phelps or some other real big cases that can be surprising, but maybe don't tell as much of a story as an amendment can.
Curtis, what do you think? What's your favorite case for amendment or anything like that?
I think I can't pick a favorite. I don't know. Favorite implies a case where I like the result, and there aren't many of those. I think if I had to pick one case, and that case was all I could study for the rest of my life, I think I'd probably pick Lochner, because you have three opinions that are, I don't know, just like paradigmatic expressions of a certain way of thinking about law. And you have a thematic issue, which is how much deference do we give to legislative determinations about the laws that the legislature is passing? And I think there's one right answer, and one terribly wrong answer, and one answer that's wrong, but could be worse. And I think there's so much there. You can start thinking about it and just sort of never stop.
Yeah, my favorite case is actually not a popular one. It's Barron v. Baltimore. I think it's an absolute correct case that John Marshall got right. When he wanted to be a good judge, he was a good judge. Otherwise, he wasn't. But this is a case held that the Bill of Rights, first 8 amendments, do not limit state power. It's a perfect decision. It's short, easy to understand, follows text and history, recognizes you can have regulatory taking in passing. I like every aspect of it. It's a good case. Yeah, Aaron, what's yours?
Well, I'm wondering how you guys would weigh in on this. The 14th Amendment's second clause. Is it simply political will that has prevented the Congress from invoking the reduction of congressional delegation for, call it, shenanigans among the states, restricting voting, et cetera? Is it simply defined by a lack of political will on the majority? Or is there something else at play that leaves the second clause of the 14th Amendment, which would reduce congressional delegations for shenanigans?
Well, for those of you who aren't as smart as Mr. Hull, Section 2 of the 14th Amendment says that Congress can reduce representation if they deprive people the right to vote. Actually, deprive men the right to vote on the basis of color. It does not say people, it says men. I understand Congress tried enforcing this in 1870, and it proved so difficult they gave up. There's actually some history they just gave up on it. It was too hard to enforce. They couldn't even figure out what the correct representation was. It wasn't an accurate census at the time. They gave up. I think that's the reason. Not clear if it has any juice today, but that's probably what happened. Chris, what do you think? Any other history?
Yeah, actually, that was right on target of actually what I was going to say. I'd also say this. I think that always looking to Congress, which has become less and less effective over the last couple of decades, as we all know, is not always the remedy that I think is and I'm not saying that it's not a good place to look, but I'm a big fan of always remembering that we now have 4 constitutional scholars who are with us today who are going to go into the world, and whether they go into law or medicine or science or anything, will now carry the ability to be civically virtuous and make local decisions possible and make state level decisions possible, which is really where power is supposed to reside under our constitutional order. So it's not that the 14th Amendment second section isn't important. Historically, Josh, you're right on point. That's what I remember in my mind too, when I'm thinking about why that hasn't really been a place that people have focused over time, because nothing happened then and it seems like there's not traction now. But I think in the greater context, I always come back to the power that's possible at the local level, where frankly, the government has the most impact, right? And at the state level, and I'm always shocked about how few people realize the power of state government, where general police power resides.
So, yes, Stephen, go ahead.
I got a question. It's kind of a fun question. What is the craziest piece of evidence you've seen used in a Supreme Court opinion? Like the most out there pieces of evidence?
Oh, wow.
One fish, two fish, red fish, blue fish.
Well, that's Justice Kagan. I mean, is this a case that the court actually accepted or a case the court considered? Because I mean,
whatever is going to get the most fun answer.
Oh man, because people put crazy arguments before the Supreme Court all the time. And it's hard to answer because what I think is crazy, someone else may think is reasonable. I mean, oh man, I'm gonna get myself in trouble with this one. One of the more, I mean, let's start with Justice Douglas. That might be a good place to start. I mean, Justice Douglas was a justice appointed by FDR. He had a long tenure, 34 odd years. He was an environmentalist and he firmly believed that nature had a place in federal court, and that like trees and water and animals had what's called standing. They can actually go to court and people could sue on behalf of animals as if animals were people. Now, I'm saying this, people litigate this issue every day, chimpanzees, owls. So who might say that's crazy? But from an actual justice, that's about the biggest doozy I can think of. Chris, what do you got?
That is, I did not remember that, but that is now resonating with me. Interesting. I would say this, because
what if the trees form a corporation though? Does that make them
give them standing?
Right.
It's funny. I'd say this in so many ways. One of the things I always impart on students is that as all of us here know, the court is hardly a monolith, right? The idea that there's these 5-4 decisions all the time is really kind of not really the facts, and not that doesn't happen, but it's not really the way that it looks. And if anything, I always emphasize that it's the individual justices like Justice Douglas that come in with opinions based on their own experiences. Let me use an example. People forget, if you look at Justice Sotomayor, I mean, her background is as an IP lawyer, right? She represented large, like Fendi and other companies that had trademark infringement issues. So she has a very different viewpoint if somebody were to bring in a piece of evidence like a shoe that they say is trademarked, or some design of a shoe that's trademarked versus other justices. Those pieces of evidence I find fascinating because they often can speak to a particular justice's viewpoints. And you can find that actually through history, just like Josh mentioned when it came to Justice Douglas and his view on environmentalism. And I think that is actually, historically speaking, some of the neater things that you see at the Supreme Court when people try to speak in particular ways to in particular cases to particular justices.
Good question. I had to give that one some thought. I only say this because recently a PETA lawyer emailed me a new lawsuit where, you ever see the Harry Potter movies? So the actress who plays Luna Lovegood sued the Department of Agriculture on behalf of 30 owls held at the Johns Hopkins University in Baltimore. So Luna Lovegood, who apparently developed an affection for animals during the Harry Potter movies, sued on behalf of the owls, the federal government, for conducting experiments on these owls at Johns Hopkins University in Baltimore. That's why it was in my mind. They're actually asserting that the federal government has enacted a bill of attainder that punishes the owls as a matter of law.
That's a wild case.
You got the bill of attainder says nothing about people. It's just that no bill of attainder shall be enacted. So, I mean, creative. Who might have said these are smart lawyers at PETA? These are smart dudes, right? This might be you guys in a couple of years. But yeah, that's why the Douglas one was in my mind, because can Luna Lovegood sue on behalf of owls? That's federal. That's what you do, right? If you shoot a woman 13 times, if you seized her, I don't know. Can Luna Lovegood sue on behalf of owls? I don't know.
Does she have any connection to said owls, or does she just
No, never
does
met
she just
them.
like owls? Like,
No, she developed an affection for animals because of the Harry Potter movies. I told you.
Well, and she shouldn't have standing, right? Because in the Pledge of Allegiance case, it was a non-custodial father, so they should be wiped out because she has no direct connection to the owls.
You're no fun. She wants to see the owls. She wants to get released. That's the purpose of the suit. She wants to see the owls, but she can't because they're captives. Look, okay, we're having fun here. I love it. Any other questions the four of you want to ask us? All right, I'll email you later tonight to your coaches the information about the classes. Hopefully you guys can come. And otherwise, we're scores we at Monday. But if we don't see you again, please feel free to reach out to us. We are excited to see all the great things you do in your lives. I forgot last hour, but I'll put my email address in the chat, so you're welcome to write it down. And if you ever want to reach out, talk about law school or anything else, I'm always happy to talk. There it is, Josh Blackman at Gmail. Easy to remember. All right, anything else in your minds, guys?
Thank you so much for taking the time yesterday and today and all the prep work, because this is not a light lift to get this all together, and it's gotten smoother and smoother and smoother every year. So thank you again. This is not, you're not getting paid, you're getting hypothetical high fives for it. So thank you very, very much for putting this on.
All right, everyone, take care. If the students can sign off, I'll talk to the coaches about the grading, and we'll be in touch soon. Thank you.
Thank you so much.
thank you so much. I appreciate it.
Thank you. Let me stop the recording.